Good morning, everyone. Welcome to the 20th meeting of the Justice Committee. Our first item of business this morning is to welcome Annabel Ewing as a new member of the committee and to invite Annabel to declare any relevant interests. Annabel.
Thank you, Convener. I would draw members' attention to my declaration in the Register of Interests to the effect that I am a member of the Law Society of Scotland, that I hold a current practising certificate, albeit that I am not currently practising. Thank you.
Thank you, Annabel, and welcome to the Justice Committee. It's great to have you with us. Our second item of business this morning is to agree to take item 5 in private, which is consideration of a draft report on the reopening of the courts. Our members agreed that we take that in private. I see no dissent, so I'm going to take that as agreed. Thank you very much. Now we're going to return to the Defamation and Malicious Publication Scotland Bill. We're taking evidence at stage 1 of our inquiry into that bill, and we have this morning two panels of witnesses. And first, I'd like very warmly to welcome Dr. Andrew Scott, Associate Professor of Law from the London School of Economics, and Gavin Sutter, Senior Lecturer in Media Law from Queen Mary University, also in London. And I'd like to thank both Dr. Scott and Mr. Sutter for their written submissions, which are, of course, as always, available for members and for the public on the committee's web pages. And before we move into questions, I invite them first to make some short opening remarks if they wish, and then, as I say, we'll get into questions. So, Dr. Scott, would you like to begin?
Okay, first of all, let me say many thanks to the committee for inviting me to attend today. So in general terms, I would say that this is a good bill, and I think that it will make some contribution to better balancing the individual and social interests in reputation and in free speech. It does some things which I think are really quite innovative and which I happen to welcome. For example, the tightening of the definition of who is to be understood to be a publisher, and the revisions to the defence of fair comment or honest opinion. For me, though, the key concern about the law of defamation is and always has been the sheer cost of embroilment in legal proceedings, or the potential embroilment in legal proceedings. That cost allows claimants sometimes to weaponise the law of defamation, but correspondingly it also creates difficulties for many, if not most, plaintiffs to access justice when they feel that they have their reputations have been besmirched. In that context, I was quite struck by the words of one of your earlier witnesses, who was picking up one dimension of that, where he referred to the opportunities afforded by the law to those with, I think it was thin skins and thick wallets. And I was further struck then when, in discussing that concept, he suggested that the problem of thin skins and thick wallets was not going to be solved probably in our lifetime, and certainly not by the bill alone, which I took to be a really rather dispiriting starting point. I mean, the truth is that when I was conducting the reviews for the Northern Ireland Law Commission and writing a report for the Northern Irish Government, I also felt that sense of deflation from the outset. And as a result of that, I felt behoven really to try and think laterally, to try and think a little bit differently about the law of defamation, and perhaps to try and, by doing so, to think of an alternative way through, so that this sort of better balance between reputation and free speech that we're all seeking might be more sort of fulsomely achieved. So as a result, then I proposed, made proposals which placed a much greater emphasis upon bringing proceedings or the resolution of defamation concerns outside of the courtroom, thereby reducing costs. And that may be something you want to pick up later on. I'll be very happy to speak to that later on.
Thank you, Dr. Scott. Mr. Sutter, do you have anything that you want to add before we get into questions?
Yes. The first thing I'd like to say about the bill is I agree with Andrew on many things. I think it's a great bill. I very much applaud the fact that it has brought most, I think, of the key issues in relation to defamation under, at least in theory, under one bill, a sort of more consolidating approach, which was not taken in the 2013 Act in England, and I think that was a real missed opportunity. Two things I think Andrew and I, as will come out in discussion, have a different take on the defining of publishers in section 3 and 4 and how that's worked out. Although the one thing I'll say on that at this stage is I think this also relates to a much broader problem with dealing with the internet, in that we're in a situation online where what should be, or what in theory in the past has always been the public square where people may speak freely subject to certain limits, is increasingly dominated by private interests providing that public space. And I think a lot of the complications are tied up in our lack of an overall answer to that general media trend. To very much agree with Andrew in terms of cost and admission, the pay-to-play side of defamation, as it were. Now, something that was given a lot of discussion and a lot of reference at an early stage in the debate on what became the 2013 Act in England was the idea of creating a fast-track libel tribunal which could reach binding decisions. And I begin to wonder whether that might not be such a bad idea in terms of the difficulties involved in costs.
That's very helpful. Thank you.
I'm not sure if I can. Okay, still there.
No, that's great. Thank you very much. That's very helpful and nicely anticipates a number of the opening questions that Liam MacArthur would like to bowl gently at you. Liam.
Thanks very much, Convener. As you say, yes, I think both witnesses, and you're very welcome, have touched on the kind of areas I wanted to delve a little deeper into. I mean, obviously, as both Dr. Scott and Dr. Sutter have alluded to, this draft bill draws very heavily on the 2013 Defamation Act. And I wonder whether or not the witnesses believe that balance has been well struck. I think they've alluded to areas where there might still be work to be done in fine-tuning that. But the sense I get is that you both feel that the balance, broadly speaking, between freedom of expression and protection of reputation has been achieved. Maybe, Dr. Scott, if you could offer any further thoughts in that regard.
I mean, I tend to agree with that. It's very difficult to be too upset with the position which was achieved in the 2013 Act. It's probably fair also to say, however, that the law was more or less balancing these interests prior to the introduction of the 2013 Act, and that Act really didn't make a profound difference in very many areas of the law. Where there are sort of quibbles with the 2013 Act, the types of change that I personally would seek to introduce tend to have been introduced in this Scottish bill. So hence I would commend the Scottish version more strongly than the English version. But I come back to the point I was making at the outset. I mean, fundamentally, what the law is, offence or the concept of the publisher, really doesn't. The problem with libel law or defamation law being the capacity to weaponize the law. Now, just to sort of illustrate that point further, I mean, we all understand that U.S. law, the United States is the land of free speech and so on. You may be aware of the fact that in the U.S. at the present time, Sarah Palin is pursuing defamation proceedings against the New York Times on account of something that her office had published, which on some people's account resulted in the shooting and the injuries caused to Gabrielle Gifford. In the United States, under the New York Times and Sullivan defense, essentially you can publish anything that you like about a public figure, and Sarah Palin here as an electoral candidate is a quintessential public figure. And the claimants can only bring an action if they can prove actual malice. So Palin is pursuing legal proceedings alleging actual malice in these circumstances. So even in the United States, and the judges, the courts are accommodating that. The case is going to a hearing now. So this is a quintessential case where you would think the result would be different in the United States as compared with other common law jurisdictions. But even there, it's possible for Sarah Palin to drag the New York Times through the legal process. Now, it may well be that she thinks she has a case and that there was, in fact, actual malice. I mean, let's not preempt the judgment. But what I would surmise is that what she's really engaged in is just warning the New York Times that any time you want to write about me or anybody associated with me or anyone from my political persuasion, there will be a cost to pay. And as I say, we can introduce piecemeal changes to the substantive law, but fundamentally that opportunity will still be there insofar as we're relying upon the legal dispute resolution mechanism.
Just as I bring in Dr. Surrey for any views he has in that respect, I would observe that last week from the representatives of from the legal profession, they saw this draft bill very much as a rebalancing towards protections of freedom of expression and diluting it in a sense at the same time the protections around reputation. Is that a characterisation that you would agree with? Maybe Dr. Sutter, and then come back to Dr. Scott if there's anything he wants to add.
I'm very much on the same page as Andrew with this one, that as he says, the weaponisation of libel law is really something that comes down to the cost of fighting a suit. And in addition to what Andrew has said, I would emphasise, and this is something we discussed, I think, in 2018 when I was last talking to the committee about this, that it's not always the case that the media, the poor journalists, are the ones being picked on by the meanie who wants to censor them. Equally, it's not always the case that the media are the meanies who ruined somebody's reputation unfairly. And I think perhaps the fact that we don't have an obvious good guy, bad guy split between the claimant and defendant aspects, if you like, is one of the things that makes this difficult. And I can't help but feel that really, through the prism, strictly speaking, of defamation law, this is something that can be solved. I do think it's a much broader issue. I have memories that at the time of when the 2013 Act was first broached, the whole issue of costs was very much raised and then kind of swept under the carpet as part of a wider civil law review in England, which of course hasn't been, then the issue hasn't been addressed since. So, I think other than if libel law sought to have some kind of fast-track tribunal, as we've discussed before, I don't think there is an obvious answer to this problem of costs within it, but that's very much the big difficulty that upsets paper. I think the bill really is very good, by and large, in balancing or seeking to balance the interests, and in particular the defences, which in what the bill proposes, and certainly what's available in English law already, are a very important part of that balance when you put them in the context, of course, that libel remains a strict liability issue, so there's no opportunity to say, oh, but we didn't mean that, oh, but we didn't intend. So, that makes it a very delicate balancing issue, I think. And as I say, overall, my feeling is the bill gets it about right, subject to Andrew and I's concerns about the cost issue.
That's helpful. It might be useful if there's additional evidence you're able to provide on the idea around the fast track proposal. You'll be aware that Scottish Pen have put forward their own thoughts here, which I think other colleagues will come on to in the line of questioning later on. But certainly further information around the proposal of a fast track tribunal would be of interest. Just in terms of this, and Dr. Scott, you referred to the weaponising of the process. Clearly, we've had evidence to date that suggests that some of these legal letters, etc., from wherever they emanate, are a means of closing down the process and leading to what has been referred to as the chilling effect. Legal stakeholders in the main suggesting this is a legitimate part of the negotiation and a way, if you like, of keeping things from having to ultimately go to court. I'd be interested in your observations as to whether, through what's in the draft bill at the moment, balancing those different rights, reducing the extent to which these processes can be weaponised, and maybe giving a degree of comfort to, I think it was Andrew Tickell who talked about the thin skins and thick wallets, and that there is maybe some hope that this issue can be better addressed going forwards. Mr. Sutter, I don't know whether you have a view on that.
Sorry, could you rephrase the question? I didn't quite catch all of that on my connection.
Right. I was just saying that in terms of that weaponising of the process, do you feel that the bill as it currently stands goes as far as it can in perhaps moderating that, if not avoiding it entirely?
Broadly speaking, it does. I mean, I take a different line to Andrew's. We'll come on to on the desirability of sections 3 and 4 as an approach, but that's another matter. I think by and large, I think it goes as far as it can with the strict letter of the law, and I do feel that the weaponisation aspect is very much predominantly one of cost, because I'm not convinced. I mean, if we were talking about a system where it costs somebody 20 quid, for the sake of argument, to bring a case, and damages might be another 20 quid, well, pretty much anybody's going to fight their corner on that. But once you start to say £2,000, £20,000, and costs are over 100,000 per day, or the figures that you see coming up in the courts down here, you start to think, well, okay, maybe I'm 99% sure I could win, but I don't think I'm going to fight the case because that's too big a risk. I don't want to lose my house over a law case, as quite literally happened with Katie Hopkins in her defamation case that she probably shouldn't have fought. But nonetheless, I think the cost is very much central to that weaponisation, chilling effect. And my feeling has long been that all the other things we could add to and say, oh, this is a chilling effect, making intermediaries liable is a chilling effect. Well, when you scratch the surface and say, well, the problem ultimately it typically is because of cost, and that's the calculation. So I think that is very much the central issue to any difficulty. The bill itself, on paper and purely as a matter of law, without putting the money into it, so to speak, is solid.
Dr. Scott, is there anything that you want to add before we move on?
Say that broadly speaking, I would be very much on the sort of pro-free speech side of any debate almost, and so I would tend to welcome things that we find in the bill. I mean, I think that potentially the most profound change is a very sort of subtly expressed one, which is the idea that in the defence of fair comment, one can rest one's comment or one's opinion on facts that one reasonably believes to be true. I agree that that's a desirable move forward, but I think it could potentially be a really quite profound move in the law. I mean, I would re-emphasize the point I made a few moments ago about the capacity for people still to weaponize the law irrespective of the likely outcome. And that's often not the goal which is being pursued, actually winning the case. I do have one concern where I think I put this in my written evidence as well, and it speaks to a couple of points that Gavin has made already about clauses 3 and 4. Narrowing the definition of the publisher to the author, editor, if you like, the primary publishers, is a desirable thing. One thing I was slightly concerned about in this bill, however, was the seeming absence of any sort of follow-on to that, in the sense that very often, if you're the claimant, the only recourse you have is to bring an action against some form of intermediary, whether it's a newspaper hosting user-generated content or whether it's Facebook or whomever. And I think merely to leave to narrow the concept of publisher so that various people who could be sued today can't be sued in future is maybe to significantly underestimate the importance and difficulty of the claimant or plaintiff's position. In the Northern Irish context, I sort of absolved myself of concern in this regard by thinking through what would then happen in the absence of liability for the intermediary. In Northern Ireland, as in England and Wales, you have a special rule in defamation with regard to obtaining an interim order requiring takedown. And essentially, this is the rule in Bonnard and Perryman. Okay, and essentially what it says is that if the defendant comes to the court and vouchsafes their intention to defend the action, then the court won't make an interim order compelling takedown or non-publication. So essentially it's a, well, we'll see you in court type rule. But I thought through how that would then apply in the circumstance where we removed the potential liability, the legal liability for the intermediary. And essentially what would happen would be that the plaintiff would go to court. They would make their case. Unless the actual author came forward, there would be no counterpoint to what the claimant was saying. And therefore, while they are compelled to give the gist of the other side of the argument to the court would be in a position where it was faced with a seemingly bona fide complaint, but nobody coming forward to saying that they were going to be defending the action. And in that circumstance, a takedown order could be made. Now, you might say that's quite a convoluted process, and it is relative to what we have at present, where you give notice and seek takedown. But the fundamental difference there would be that it would be like a legal determination issued by a judge on the gist of the case as to where the appropriate balance between the Article 8 and Article 10 interests were at stake. Now, I surmise that the same type of opportunity would be available in Scottish law, but I'm not a specialist on Scottish civil procedure. As far as I can see, with the Sheriff's Court, it looks like there might be an opportunity to quickly gain takedown via legal route, and that would address the concerns over access to justice for the claimant, while also avoiding collateral censorship by potentially liable intermediary publishers or secondary publishers.
Thanks very much. Thanks, Colleen.
Well, thank you. I want to move on to the question of how defamation is defined, and indeed whether it should be defined as such in the statute. This bill does include a definition of defamation. Can I ask Dr. Scott first? Is that wise? Is it right that the legislation should define defamation? And do you have any reflections on the definition given in the bill? Are there any ways in which it could be improved on?
Okay, well, I'll answer the second part first, which is to say that I think it's as good a I do think that there's always defining something in law. If you compare the position in the common law in England and Wales, which is sort of neatly expressed in a case called Thornton and Daily Telegraph, what you find there was Mr. Justice Tugendhat setting out, 10 or 11 or 12 different definitions that have been used over time by judges in the English courts. And those definitions tended to speak to slightly different factual circumstances. So the definition of what it meant to be defamatory, which was applied in the context of a corporate claimant, might be subtly different because of the different interests at stake to those which would be applicable in a much more, let's say, domestic case. We find in a case called Simmons Stretch, which is pretty similar to what you find in is it clause 1 of the Scottish Bill. So insofar as that definition is interpreted, with nuance by the Scottish courts, I don't see any real problem. But subject to the sort of general caveat about putting anything down into legislative terms.
Yeah, thank you very much, Mr. Sutter. Anything to add on that point?
I wasn't able to catch everything Andrew says in my connection, but by and large, as I said in my submission written to the committee, favour of a positive definition. I think the English courts got sort of halfway, or the English legislature, should say, got halfway there with the 2013 Act sort of giving a kind of negative definition in a sense, and on that point I disagree with interpretations respectfully of the Court of Appeal in Le Show, who said that it wasn't it seems to me the definition is very good. It's something that is long overdue. The Fox Committee called for 1975, and I think they were right then, and they would be right now. The definition in the bill is a pretty good general definition. The only thing I would suggest adding to it, particularly in this context in Scotland, where there was a long debate about whether you should be able to protect a dead person's reputation in defamation, which came in light of the very tragic Watson case, I think it would be worth inserting that as regards natural persons, it should be a living person can be the subject of a defamation rather than leaving that open to question, as I say, because that was a very specific debate that was had there, and I think it's worth just sort of putting that point in very clearly in the law, that it's living people whose reputation can be damaged in this sense. But other than that, as I say, I think what the bill proposes is a very solid definition, and I think it's a real shame that the 2013 Act in England and Wales didn't do something similar.
Okay, that's helpful. Listen, can I just say to both of the witnesses that both of your connections are cutting out intermittently, and we're having some difficulty hearing everything. I think we're all getting the gist. But if I could ask, please, for much crisper answers, then that I think would help. We've still got quite a lot to get through. We've only asked a couple of questions so far. So if we could just speed this up a little bit and bear with us if we don't catch everything, that would be extremely helpful. Thank you. And with that in mind, Rona.
Serious harm test.
Sorry, Rona, your mic was muted. Could you start again, please?
Yeah. Thank you, Convener. Good morning, panel. I'd like to move on to the serious harm test, which is contained in the Defamation Act 2013. Mr. Sutcher, if I could come to you first. I see from your submission that you're in favour of this, and I wonder if you could just expand on that. And do you think it's been successful in protecting against this alleged chilling effect of defamation claims?
It's worth setting out in statutes. Given that the interpretation by the Supreme Court has actually set it at a fairly low standard and arguably not law as was previously, I don't think it has made a really significant change in practice post-Lishow in that sense, but I do still perversely think it's worth having it there to clarify effectively for non-lawyers in many ways.
Okay, thank you. We've heard concerns, from previous witnesses that the test in England has proven to be complex and resource intensive for courts to operate, and we know there are far more defamation cases in England. Do you agree with that? And do you want to sort of compare what would happen in England as to what we're proposing in the bill?
I think Andrew's done a bit more direct research on this specific point than I have, so he could maybe answer that clearer. My feeling is that it is appropriate. It has meant there is an extra stage in cases. I think what I would want to see going forward would be how many cases it actually ended with that. Because if it's not stopping many cases coming forward, if very few cases fail that test in one sense, then there maybe is an argument that, well, what difference does it make? If you follow me, but I think Andrew has done more work than I have on the exact sum of that in practice, so I would defer to him on this one.
Thank you. Dr. Scott, if I could ask you to comment on that. And also, I'm quite interested to know what you think of the threshold. What would that test? How high should that test be set? How high should the bar be set on it so that it would make a difference?
Okay, so in the English debate, we were talking about compare and test with the threshold of seriousness, which we derive from common law and Strasbourg jurisprudence. To me, that's a question of semantics. We're talking about something having to be a significant defamation. The real issue with the serious harm test in the English courts, now, as Gavin has suggested already, it's been interpreted and reinterpreted as it's gone through the show litigation. We started off with Mr. Justice Warby saying that the test was a higher threshold, and importantly, evidence would have to be pled in order to meet the threshold. The Court of Appeal then said that ultimately, no, it's pretty much the same as we had in the common law, so inferences are fine, and there'll be no additional hurdle. But the Supreme Court has come back and reiterated Mr. Justice Warby's view. Now, what that means is that very often, whereas we thought that serious harm would be a threshold question and it'd be able to be dealt with at a preliminary hearing, very often it's going to have to be heard at a substantive hearing at the end point of the legal process. And very often you're going to have significant evidence pled in order to show that you've met the threshold. So that adds cost and complexity to the legal proceeding. I mean, in the Northern Irish report, I sort of pled, what's the word? I suggested I was neutral on it, because at that time, the position in law in England was that held up by the Court of Appeal. I'd be much more circumspect today, I think, about the introduction of a serious harm test, which required substantive pleading of evidence in court. Now, there is a sort of rejoinder to that, which is to say that the Supreme Court left room for, the finding of like inferential harm, if you like. So it's possible to presume harm still under the Supreme Court's position, but ultimately that's going to happen in some cases and not all. And I can certainly concur with the earlier witnesses that you've had who've been worried about this.
Yeah, it would seem to me to defeat the purpose if it has to go to the Supreme Court when the serious harm test is meant to be there at the outset. So
okay. So with any new rule, with any new rule, you're going to get some sort of interpretation of it over time in the courts. But I suspect that actually the attention given in any proceedings, in any litigation to this question is going to be much greater than you might have hoped when introducing it as a sort of gateway test.
So I'm just taking from that then that you're not convinced by it.
Yeah, certainly. As I say,
it should be
when reporting to the Northern Irish government, I thought it could work okay, but actually today I'd be much more circumspect and more concerned.
Okay, thank you. Thank you for that.
Okay, thank you, Rona. That's very helpful. John Finney, next, please, to ask about Section 3 of the bill and the Derbyshire Principle. John.
Thank you, Convener. Good morning, panel, and I'll direct the question in the first instance to Dr. Sutter. All aspects of this bill about the balance between the freedom of expression and protection of individual reputation. The Derbyshire Principle, the ban on public authorities suing for defamation, is in this bill, and there's a statutory definition that will include arm's length organisations and other bodies, and that reflects the different models of how service delivery of public services takes place in Scotland. There's an exemption for businesses and charities engaged from time to time. Now, the differing views that are in this are that media concerns rightly about effective scrutiny, whilst the legal profession have expressed some concerns that this has been drawn wider than at present. And also we've heard about implications for individuals such as doctors. I wonder, in the first instance, Dr. Sutter, then yourself, Dr. Scott, if you could comment on the Derbyshire Principle application in this piece of legislation, please.
Yeah, certainly. Firstly, I am very much in favour of Derbyshire as a way of preventing public bodies from using libel as a shield against public accountability. I have two concerns. One, I don't think there's a clear answer to, and that is the general principle. It has been shown in research that in England and Wales there have been a number of local councils who effectively subverted the Derbyshire Principle by the party quietly funding an individual to protect their reputation as an individual, whereas, of course, when they were cleared, that by implication cleared the party, and there's a concern about abuse there. My concern specific to this bill is in Section 2.3, it says it is not a public authority by reason only of its carrying out functions of a public nature from time to time, which you specifically refer to in the question. Now, my concern there is, maybe it borders into paranoia, but my concern there is that we could see the potential for a public body doing something they feel might be controversial or that they don't want to be critiqued, deliberately outsourcing in order to use the outsourced company as a shield for the Derbyshire Principle, and that is a concern I have. My feeling is if we are going to permit an outsourced body to act in a public concept, then the law here should work, as indeed it does with elements of human rights law like Article 10 and so on. A private body acting in the capacity as a public body and on behalf of a public body should be treated in all aspects as a public body, in my view, including the Derbyshire Principle.
And I wonder, Dr. Sutter, can I ask you to clarify that? So what would the linkage be there? Public expenditure connected with the function?
Well, yes, essentially the activity, whatever it is, would be carried out on behalf of a public authority. It's being done with taxpayers' money. It should be accountable in the same way as the public body would be accountable for any other activity. Just because they've outsourced it to somebody else, I don't think should be open to that abuse to evade scrutiny, if you like. And I think that's part of the concern.
So, Dr. Sutter, can I push you on this? And I'm trying to imagine a situation where some multinational corporations run public services in Scotland, but similarly, a village plumber might do work on the village primary school or the hall that's in local.
Oh, yes, sorry. Something on that level, no, that's fine. I'm thinking of where a major infrastructure project is contracted out, or something like one of the privatised contracts for, to run a railway, or, that kind of level, big level stuff, not individuals or low level. I mean, clearly there would have to be, you're right, a clarification of the level that this applied at, but I'm thinking of, very significant bodies where they would be acting long term in, or doing very specific projects, dealing directly with the public, such as, I live in my flat from which I'm speaking today is an ex-council flat. The management of the block day to day is outsourced to a private company. That's the kind of scenario I'm thinking of.
Thank you. I don't know, Dr. Scott, would you have any views on that, perhaps briefly, please?
Well, I think in light of the convener's instruction, I'll pass on that question. I don't have anything very substantive to add.
Okay, thank you. Dr. Scott, can I maybe come to you then in a secondary point connected with this, and that is that some media stakeholders have argued for wider restrictions on businesses' ability to raise defamation proceedings. Scottish Pen proposed that only companies with fewer than 10 employees should be able to sue for defamation, so-called Australia model. Do you have views on that at all, please?
Australian model to begin with. Not dissimilar just a moment ago. In Australia, under the rules governing corporate right to sue or corporate standing, there's nothing which restricts like a corporate director or manager from suing on their own behalf, and thereby, it's possible to circumvent that type of restriction. More generally, I'm sceptical about the desirability of limiting corporations' right to sue per se, on the basis that corporations, companies' primary asset these days is fundamentally their reputation. So it seems almost bizarre that one would prevent them from the right to utilise the cause of action in delicto, which should give them immediate access to the court to defend their reputation. I would much prefer an alternative that I think Scottish Pen put forward, which would be to assess the impact of actions brought by corporations, and when they were talking about what in common parlance would be referred to as anti-slap legislation. So if a corporation is bringing an action which may be designed but certainly has the effect of preventing a critic in the public sphere from making their point volubly, that type of action should be addressed rather than the general action being brought by corporations. It should be said as well, by the way, corporations tend not to sue in libel. I mean, they have many other devices, or defamation rather, many other devices available to them to defend their reputations. You know, and if you review reputation management textbooks, I mean, law barely gets a mention.
Okay, thank you very much indeed. I'll leave it there, convener. Thank you.
Thank you, John. I'm going to bring Annabel Ewing in a second. Before I do so, can I just explain that we've had to cut the video feed for Mr. Sutter, so he's audio only at the moment, and we're all able to hear him much better now. So I'm sorry that we can't see you, Mr. Sutter, but we can hear your evidence now much more clearly than we were able to before. Annabel, I think you want to take up the theme of looking comparatively at aspects of defamation.
Yes, thank you, convener. Good morning to our witnesses. On picking up actually in terms of some of the points that our witnesses made earlier about, whilst they think the bill by and large gets it right, nonetheless, there's the bill actually operating in practice in terms of people to avail themselves of the bill one way or the other. So in that regard, I understand that there's a pre-action protocol in England and Wales for media and communications claims in general, which would include defamation claims. And I just wonder if either of our witnesses would be aware of how that is working in practice in terms of providing at least a partial solution along the way to some of the issues that you have both highlighted. Perhaps we could start with Dr. Scott.
Well, I profess that I have limited personal experience of this. I mean, the purpose of the pre-action protocol, of course, is to sort of narrow the field of the contentious field, if you like, so that as the case goes through the litigation process, it tends to focus on the real concerns, the crux of the issue, and that allied with like active judicial case management, which has been very much a feature of legal proceedings in this area over the last 5 or 10 years in England and Wales. You see, the much more efficient resolution of libel disputes. Beyond that, I can't really comment on the efficacy of the protocol directly.
Thank you. Dr. Sutter, do you have any comment?
Nothing to add really to what Andrew said, no.
Okay, thank you. Turning to the issue of looking at the defamatory meaning of the words employed in any instant case, as you will be aware, there's been a suggestion that there should be a quick court procedure to look at that specific issue, and it would be interesting to hear your thoughts on that suggestion. Perhaps again start with Dr. Scott.
Thanks. Sorry, Ms. Ewing, I was asking, are you saying that there's been a proposal in Scotland for there to be early hearings?
Well, it's not in the bill, but it has been, I understand, in the evidence sessions thus far, it has been a suggestion that this would be a help, but it would be a question of looking at that in the round and understanding what it would mean and in terms of precedent, how it has operated elsewhere.
Okay, so, I mean, you would think that this question should be very easily determined. I mean, the legal test, if you like, is an impressionistic one. I mean, what would the average person understand the publication or imputation to have meant on a bare reading or a passing hearing of it? In fact, I mean, there is effectively an early determination of this in the English courts, in that it's invariably one of the preliminary matters which is brought to the court before we ever go near the substantive hearing. So this is one dimension of that judicial case management that I was talking about earlier on. This is something I've been particularly interested in. I mean, in my written evidence, I give some details on research that I've been undertaking. I think the bare fact is that it's something over the course of the since 2014, the average number of days taken for those preliminary hearings to reach a resolution on the meaning of a phrase which the average person is taken to understand on an impressionistic basis, is something like 580 days. So that's 580 days of lawyering, 1 or possibly 2 legal hearings. And you're talking, in some cases, you've been in excess of £100,000. But in general terms, you might be talking tens of thousands. Yes, it seems to be a very sensible thing to do. And I think in terms of like rationalising litigation that is going to go through the whole way through the courts, it's highly desirable. But it doesn't take you away from that situation where like the embroilment in libel proceedings becomes just a game you don't want to enter at all because of the cost of it. I mean, this is precisely the point that I was speaking to in the Northern Irish report, the report to the government, where I was saying, well, how could you actually do this differently? I mean, I've given you evidence in written form on that, and if you want to ask any questions about that in particular, then I'm happy to respond to them.
Thank you. A general question, I mean, I think you've both referred to the fact that in some areas the 2013 Act is deficient. Looking at the bill before us here in Scotland and taking account of that experience of legislation down south, is there any key issue that you think, leaving to one side, availing yourself in practice of the bill, is there any key issue, one key issue you think that the bill is failing to deal with or is not dealing with sufficiently well? I'll start with Dr. Scott and then go to Dr. Sutter. Thank you.
Okay. Well, following on from my last comments, first of all, I'd say the determination of meaning. To my mind, the determination of meaning could be taken outside of the court process altogether, and so that only actually contested meanings would ever go to court. So at the minute we have like hundreds of days of arbitrage between either side, which is just, it's unbelievable, because, the simple question we're asking is, well, what did this mean? And the answer should be a very straightforward one. The other issue, and this is my answer to your question, is something that I've already alluded to in the Scottish Pen advice, or evidence rather, and that is the potential desirability of anti-SLAPP legislation. This is something which, if you're thinking about comparative perspectives, this has been introduced in many US jurisdictions, but more recently in Ontario in Canada. And their approach is really very interesting indeed, in that they solve a perennial problem with anti-SLAPP legislation. The notion of a SLAPP is a strategic lawsuit against public participation. So it's the bullying action, and very often the bullying defamation action. So what anti-SLAPP legislation usually does is allow you early means of having a court strike out that action, and in some variants of it also then recovering damages for the impact upon your freedom of speech, which gives the incentive to the individual to pursue the action, but also then has a collateral benefit for a wider society. So what the Canadian version of the Ontario law does is it focuses upon the effect of what is being proposed, the action which is being taken, rather than moving into the more murky territory of trying to understand the motivation of the litigant, the plaintiff. So it's quite quick, it's quite neat. There are some, it's quite new as well, but there has been some research undertaken into its efficacy, and I think that's something that the committee and Scottish Parliament more generally, I think, might benefit from adding into this bill.
Very interesting. Dr. Sutter, any particular point you would wish to make in terms of, the bill, what is missing in terms of key issue or what could be refined?
No, I think Andrew raises some. Oh yes, I think Andrew raised some very helpful ideas there with the anti-SLAPP, and that certainly is something that could potentially be worked in alongside the notion of a tribunal of sorts. Although I would see the tribunal side as arising from something separate rather than this legislation. Otherwise, aside from the critiques that I've mentioned in my written evidence, I think the bill as a whole does address all the key issues tossed aside.
Thank you. It's very rare that we get witnesses who think our bills put forward are in such good shape, but it's interesting to hear, and a very interesting suggestion. We'll look at that carefully. Thank you. Thank you, Convener.
Thank you, Annabelle. We're going to turn now to what is, I think, technically quite a complex area of the bill, namely provisions pertaining to secondary publishers. And Rona Mackay is going to lead the questioning on this. So, Rona, over to you, please.
Thank you, Convener. Yeah, I mean, I know this. This has been discussed earlier on in the session, and I don't propose to go over what's been said already, unless you want to expand on that. What I would like to do is focus right in on the fact that the bill doesn't deal directly with online publications, although obviously excluding secondary publishers would have a huge impact on that. So do you think there should be more focus on online publications within this bill? And could I have your thoughts on the UK government? They have proposed reform to internet regulation on its online harms white paper. What do you think the impact of these developments would be on online defamation? So if I could just have your thoughts on a huge issue, obviously, of internet regulation. If I could go to Gavin Sutter first, please.
Yep, certainly. Firstly, to the point about whether it needs to reference online directly, I don't think that's necessary. I think it's clear enough from sections 3 and 4 that this is very much drafted with the online focus in mind. In terms of the online harms bill, and I know I referenced that in my written evidence, it's still not quite clear where that's going in England, but the broad substance of the idea was to make social media providers responsible, give them a duty of care towards their end user, and it's possible that a number of the harms they identified, such as cyberbullying, could have a direct crossover with the issues involved in defamation, which could have the advantage that it would give a number of claimants who might not otherwise bring or feel emboldened or feel able to afford to bring defamation proceedings. My concern with the online harms issue, however, is how much of the harms identified aren't actually illegal things. I'm a bit concerned that it could have a chilling effect on expression and on speech, and I'm not convinced of the practicality of trying to bind in that way a giant like Facebook, who have very openly in the past stuck up two fingers to many states in terms of their law and said, we're Facebook, we do it the Facebook way. So I don't think we could rely too much on the online harms as an answer to these issues, certainly as affect defamation.
And so would the serious harm threshold apply online too? And presumably it would.
Oh yeah, well the law as it's drafted does not direct itself towards any particular medium for publication. It applies to online in the same way as the libel law, when it applied to print originally, also then came to apply to broadcast when that came along as a mass media.
Thank you. Thanks. Dr. Scott, can I have your views, please?
Yeah, certainly. On the issue of whether there should be explicit reference to the online context, I would concur. I don't think that that's particularly advantageous. As Gavin has suggested, we've seen the development of various rules in the common law and in this legislation, which plainly speak to the online context, and but might have some bearing upon, the traditional forms of publication, and therefore it's simply unnecessary, I think. On the question about secondary publishers, sort of referring back to what I was talking about earlier on, one additional thing that you might be aware of, if you recall, I was suggesting that the Scottish bill does a good job in absolving secondary publishers of potential liability. That was also the position reached in the Ontario Law Commission's consideration of this issue, and it's really that I want to refer you to. They rested their viewpoint very much upon the work of two Canadian scholars called Emily Laidlaw and Hilary Young. Now, their proposal married that removal of potential liability from secondary publishers with the possibility of a public fine being imposed upon publishers if they fail to interact with the claimant and the primary author in the way prescribed in guidance. So that sort of took away the liability issue, albeit that it sort of reintroduced the potential stick of public fining. But worthwhile looking at, I think, definitely.
Thank you,
I have no
that's
further
helpful.
comment really beyond what Gavin said about online powers.
That's helpful, thank you.
Excellent, thank you very much. James Kelly is next. He's going to ask questions about the defences that are provided for in the bill. James, please.
Thank you, Convener. Yeah, a question about defences, and go to Dr. Scott first and then Gavin Suter. But just in terms of the defences that are set out in the bill around truth, honest opinion and publishing in the public interest, what's your view on those? Do you have any concerns, or do you think they're adequate?
Okay. So I think in my written evidence, I raised a point about the defence of truth. I want to renege on that point because I think I was guilty of not fully reading the bill as it's set out. I was querying whether it was obvious or clear whether what was intended was like a reiteration of the English law or the existing Scottish law, or the introduction of something known as contextual truth, which is familiar to Australian jurisdictions. I think it's palpably clear that it's the former of those, and that's fine. There's the normative question left open about whether a defence of contextual truth would be desirable. In this regard, I just note, I suppose, that New South Wales has recently revised its defamation law. So it's moved away from the uniform defamation laws introduced in Australian jurisdictions in 2005. It hopes as a sort of a precursor to similar changes being instituted elsewhere. What it has sought to do is to clarify its defence of contextual truth, which is found in Section 26 of the 2005 Acts. They clearly think it's a desirable facet of the suite of defences. You might want to look at it. I wouldn't necessarily propose that. What I think is really very desirable is one of the changes instituted in the defence of honest opinion. I think I mentioned this earlier on. This is the idea that where formerly, in order to be able to defend your opinion or comment, you had to be able to show that the underpinning facts were true or privileged. What this bill does is extend that to facts which you reasonably believe to be true. Okay, and I think that will help Scottish law move. And that's innovative, by the way. That hasn't been done anywhere else. That will help Scottish law move away from the surfeit of technicality in this area of law, because the debate is very often in honest opinion context not about the validity or otherwise of the comment or opinion that's been expressed, but rather whether the underpinning facts were true. And the fact is that depending on the factual circumstances that you're speaking in or publishing in, you may have no way of determining whether something is true. So, for instance, if I am blogging on something that I'm hearing in the Scottish Parliament, or that's a bad example, I'm blogging on something that I'm watching on Newsnight or that I read in the Times, I have no way of knowing whether, if pushed, the Times or Newsnight would be able to prove their case. So I'm entirely reliant upon the adequacy of their legal checks. This innovation will mean that if it's reasonable for me to adopt the position that what I'm hearing is true, then I can express my opinion, which is precisely what we want journalism for. We want journalists to be investigating matters of public importance, publishing on them, and thereby informing the public. And then we want the public to communicate to one another about what they've heard. I mean, that's the very basis of public information. So this defence will allow that to happen to a very much greater extent. It might be too great a defence for freedom of speech, but as I intimated earlier on, I think that's something that I'm happy to see. But I can certainly see counterpoint on that issue being raised with you. But for me, it's a really desirable reform.
Okay, thank you, Mr. Suter.
I completely concur with Andrew's point that a defence of honest opinion, including an explicit reference to an honest mistake being the basis of that, is a very good move. broadly speaking, I'm in favour of all the defences in the Act, actually. I mean, if I'm being nitpicky, as I mentioned in my written evidence, I'm uncomfortable with truth being used in place of provable fact. I would much rather have a defence of fact when we're looking in the context of a court deciding on the basis of the balance of probabilities, but I know that's a minor point. A minor point I'd raise, which I do think is important in relation to the public interest defence. Now, I think this is a very good defence. It clearly reflects Section 4 in the 2013 Act, but I think it's actually much better laid out and much clearer than the Section 4 attempt to put Reynolds privilege on a statutory footing. The only thing I would suggest was, I think in the English bill, it was originally the defence of responsible publication on a matter of public interest, and they dropped the word responsible from the final act. And I think that's a shame, because saying that it's responsible publication really hammers in that point that this is a defence for responsible journalists genuinely acting in the public interest. It's not an excuse for, well, we can't do truth, we can't do honest opinion, so let's try and wheel this one out. The only other point I would really make on defences is to congratulate the drafters of the bill on how well they have laid out the offer to make amends defence, because I think that's a very important one in helping to say to people, look, behave like adults, sort it out between yourselves. And if somebody has been unreasonable, to have that for the other party to rely on in court, where appropriate, is really useful. But it is wonderfully drafted and very clear, and far surpasses what remains in England under the 1996 Act in terms of its clarity. So I think that's, no, nothing else I'd like to say about defences at this point.
Okay, thank you. That's very comprehensive.
Thank you very much. Again, Liam Kerr has two questions, one about malicious publication. And Liam, do you want to take your question about limitation at the same time? So Liam Kerr, please.
Yes, I will. Thank you, Convener. I have three questions around malicious publication, but I shall be appropriately brief, Convener. So this is part two, gentlemen, on malicious publication. The bill will create a court action for malicious publication to protect business interests. Now, the serious harm threshold does not apply to malicious publication. Dr. Sutter, you specifically say in your submission that you are in favour of a serious harm test. If the committee is minded to agree with that, should a serious harm test also apply to malicious publication?
I mean, really, I think this is the context in which the idea of a serious harm threshold originally arose. If you may remember the McDonald's and Steele case, otherwise known as the Libel Trial, which was the longest and one of the most expensive libel trials in English legal history, and actually ended up in the Court of Human Rights over the issue of inequality of arms and expenses and so on. And I mean, it's another case that links back to our earlier comments about cost as a prohibiting factor for people fighting cases, even when they have a good case. But certainly McDonald's and Steele inspired the idea that a business should have to show that a reasonable level of harm before it could bring a case. And I would actually be quite comfortable with applying, very comfortable with applying serious harm here. I think there's an argument to be held that maybe this malicious publication action is more appropriate for businesses to protect themselves than libel, but I wouldn't go so far as to cut them off from libel.
Thank you. I'll ask Dr. Scott the next question, and Dr. Scott, perhaps if you take a different view on the serious harm question, you could just very briefly elaborate on that. But I was particularly interested, Dr. Scott, in your comments on secondary publishers. The bill, as drafted, would exclude secondary publishers from liability for defamatory material. However, it appears that that may not be the case for malicious publication. Do you accept that? And if so, is that a lacuna that requires to be filled?
Liam, I confess that the area of malicious publication isn't something I've paid particular attention to. On the serious harm dimension to it, I just refer you to the comments I made earlier with regard to the potential escalation of costs associated with it. Listening to you now, it sounds interesting and perhaps curious that there is a difference in approach adopted. I'd certainly want to interrogate that, but I'm not personally in a position to do that.
Thank you, Dr. Scott. Dr. Sutton, do you have any view before I move on to a third question on this area?
On that, no. I mean, again, it's this particular angle. The malicious publication is not an area I have much specialised in. I believe the English equivalent is long gone. I would say that really all I can say at this point is, if it is intended to be an alternative to libel, as an alternative way of businesses protecting themselves, it may have a different shape. If it's considered to be a very similar action to libel and you want it held to the same standards, then uniformity in all aspects may well be preferable. But I think that's not a question I could call at this point without further research.
I'm very grateful. I shall move on to a final question, and I'll direct it specifically to you, Dr. Sutter. This is limitation. There are differing views on the reduction of the limitation to 1 year. Legal stakeholders seem to suggest that 1 year might be too short. Others take a very different view. You, Dr. Sutter, support the reduction in your submission. But when I was looking at your submission, it seems that your argument has been cut off, at least in the version I was looking at.
Yes.
Would you mind delivering me that argument, deliver your argument and persuade me that 1 year is appropriate, as briefly as you're able, please?
Yes, apologies that I'm not quite sure what happened. It may have been lost in the formatting. What I'm saying was, I approve of the measures, in particular the reduced time limit for bringing a libel action. The speed of modern media cycles has rendered the old 3-year period unnecessary, and any injustice that might otherwise occur with this shorter period can be addressed through the statute of limitations, which provides a judicial discretion to hear a libel case outside of the normal limitation period if they feel that's in the interests of justice. For example, that happened about 10 years ago now. In the High Court, the singer Stephen Patrick Morrissey was allowed to bring a case 4 years after the original publication on the basis that he was aware of it at the time, he wanted to bring an action, but he was too busy being sued by other former members of the Smiths and losing a case on unpaid royalties, and he brought the case as soon as he could raise the funds to bring it, and they actually allowed it to go out. Now, after that, it's settled. But the bar really for interests of justice is relatively low, the case law would suggest. And I think it's reasonable to place that in the hands of the judiciary. In terms of the 1 year period, that actually in some other jurisdictions is considered quite long. In France, I'm reliably informed that they allow you 4 months to launch your action if it has been mentioned in a newspaper, on the assumption that if it was really going to damage your reputation to the point where you would bring a case, you would kick off much earlier than that. Now, I think that's a little bit low, but a year to me feels a reasonable time to make that decision and to file suit.
Thank you. Thank you very much. That's very helpful. Fulton McGregor, please, next. Fulton.
Thank you, Convener, and good morning to the panel. I wanted to turn to the subject of court orders to remove material. And so far we've heard some conflicting evidence on this, with some expressing concern and some being in support of it. Media stakeholders in particular have expressed concern that Section 30 of the bill would enable a court to order a third party to remove contentious material as an interim measure, or its defamatory nature or otherwise have been reached. Do you, as the panel, think that interim measures are appropriate in this context? Convener, this is my only question, and I'm quite happy for the panel to answer it in any order.
Thanks. Let's go to Dr. Scott first then. Thanks.
Okay, really, in this area, I just refer you again to the point I was making earlier on about the Bonnard and Perryman rule and the relative difficulty that it introduces for claimants to have material taken down at an interim stage. And that, as I say, is a hedge in favour of freedom of speech. It's something which is beginning to be contested on human rights basis, and the bare rule maybe doesn't allow for an appropriate balancing between Article 8 protection of reputation and Article 10 freedom of speech. It was accepted as legitimate in a case called Green in the Court of Appeal in about 2006. The Strasbourg jurisprudence has moved on since then. But I mean, to me, the desirable position is very much, publish and be damned. In this context, at least, where what we're talking about is truth rather than invasion of privacy.
Thanks.
Yes, I would tend to agree with Andrew in terms of, because of course in the UK we've traditionally seen privacy and libel as representing different things, the public and the private persona, if you like. And I think there's a justification for the Bonnard and Perryman position on the basis that with libel you have the chance to clear your name with the ongoing litigation, whereas with privacy, once it's out there, it's out there. The only flag I would raise is that it's not entirely unusual for this to be reached around in many cases. For example, the Beckhams very famously took an ex-nanny who sold her story to the press to court, and although they later were really launching a libel action against her, which they ultimately settled out of court, initially they were able to prevent much of the material being published because they cited it under a confidentiality agreement in her contract. So in some cases, there will be a reach around in the Bonnard and Perryman rule that suggests there may be more limits to it than it presents on the face of it, if there's an overlap with your defamation and potentially confidentiality. But other than that, I don't think it's a problem. I think it's reasonable to potentially have that clause in the bill, but subject to the approach that it would only really be where it's considered absolutely necessary and justifiable on the Article 10, Article 8 balance.
Thanks, that's helpful, both answers, so I'm happy with that, Convener.
Thank you very much, Fulton. And the final question will come from Shona Robertson, who's been waiting very patiently. Shona, please.
Good morning, panel. I want to ask about the Scottish Pen proposals that I'm sure you're aware of for a new court action to provide protection from unjustified threats of defamation action. I'd like to ask your views on this, and we go to Dr. Sutter first, please.
I've not seen the full detail of their proposal exactly, but in terms of the key idea, I don't think it's unreasonable. It seems to me that this is something that would be a logical broadening of existing harassment laws, that you would logically feel that if somebody is harassed by threats of legal suits, where that is done in bad faith, that is something that the law should prevent in the interest of justice. So in terms of the broad concepts, I would be favourable towards that.
Okay, could I ask Dr. Scott the same question, please, and just maybe add whether you think, even if you agreed it in principle, whether it's workable in practice?
Yeah, so here I again refer you to my comments earlier on about the position in Ontario. I haven't seen the details of the proposal either. The traditional concern about measures of this type have been based around Article 6 and the right of access to the court. That's why the Ontario version places a great emphasis on the effect, the Article 10 dimension, if you like, rather than motivation, which would be picked up by, say, any requirement of bad faith, as Gavin has referred to there, which would be quite the norm in US versions of this law. So beyond that, I would just say maybe have a comparative look at the position in law in Canada. But in general terms, it's highly desirable. I mean, if our concern is about the weaponization of libel law and defamation, why not have a direct a cause of action or a response which allows you to directly respond to that perceived problem? So yeah, all for it if it can be made to work.
Okay, thanks. That's me finished, convener.
Well, thank you very much, and that ends this set of questions for this panel. Can I just thank Andrew Scott and Gavin Sutter very much for their time and generosity this morning. I'm sorry that we had one or two technical glitches along the way, but we got there in the end. We will now suspend for 5 minutes to enable a changeover of witnesses, and we'll reconvene at 11:21. Thank you. Welcome back, everyone, and I'd now like to welcome our second panel of witnesses for today. We have with us now Mark Scody, Senior Corporate Counsel at TripAdvisor, and Ali Tibbett, a journalist and director and co-founder of The Ferret. Thank the witnesses for their written submissions, which are available on the committee's web pages. And I invite them, before we get into questions, to make a short opening statement. Mr. Scody, would you like to start?
Yes, certainly. Thank you. TripAdvisor broadly welcomes this bill. As others have observed, it tips the balance of Scottish defamation laws towards freedom of speech. And so from our point of view, this helps to reduce a potential barrier to consumer speech online, which in turn benefits not only travellers based in or coming to Scotland, but also benefits travellers and business owners in the global travel industry and ecosystem as a whole. TripAdvisor is the world's largest travel website, which means that it features more than 860 million reviews and opinions on 8.7 million places to stay, places to eat, things to do. It's TripAdvisor's belief and its experience that the more travellers can share their experiences, good and bad, with the rest of the travelling public, the greater the benefit for all involved. The vast majority of businesses listed on TripAdvisor well understand this, and they see user review websites as word-of-mouth reviews can provide some of the best advertising they could ever get, whilst mixed or negative criticism equally provides them with swift insight as to things that can be improved. But very exceptionally, you do see that some businesses respond differently to the criticism. They can react in a more adverse manner. They can sometimes be unwilling to accept it, and the result can sometimes be that they'll attempt to have recourse to defamation laws in one jurisdiction or another. Sometimes they'll go to solicitors or lawyers in the jurisdiction. Sometimes they'll go to online reputation experts in order to clean up, supposedly, their online reputations, and defamation laws can be deployed as one of the weapons that we may see in action. Against that background, we welcome some of the reforms that come in this bill that redress some of the weaknesses that might otherwise be present under the existing Scottish legal position. Not only for the consumers writing the reviews, but for the online platforms hosting that speech. These reforms, we think, reduce the likelihood of travellers being cowed potentially into self-censoring what would otherwise be useful statements and public records of their own experiences of businesses trading to the general public. Equally, they reduce the potential need for online hosts of such material at great scale, to make excessively cautious decisions to remove material that, so far as they could otherwise tell, appear to be perfectly lawful. Specifically, we welcome the shortening of the limitation period from 3 years to 1, in line with the English and Welsh position, the raising of the seriousness threshold, and the introduction of the serious financial loss requirement, again, mirroring what happened in England and Wales for corporates trading for profit. We very much welcome the introduction of the single publication rule, which would remove the otherwise somewhat unreal position that internet publications are infinitely actionable forever. And lastly, although this may have been addressing a problem that wasn't a huge problem in practice, we do welcome the rule limiting the potential phenomenon of libel tourism in Scotland, and the rules tightening when the Scottish courts would or wouldn't have jurisdiction. London has been shaking its former reputation as the libel capital of the world by virtue of its own reforms some years ago. And there has been some discussion that other fora might take its role, potentially the Republic of Ireland, potentially Sydney. So we welcome this attempt by the Scottish legislature to guard against that. Lastly, on the positives, the strong positives, we welcome the innovative and thoughtful attempt to really pin down who is and who is not a publisher. In particular, Section 3.4G, which clarifies in a way that I haven't seen quite so explicitly in other jurisdictions, that a website operator can moderate content in an attempt to be a responsible host of third-party speech, but not necessarily get put on the proverbial hook for potential defamation cases, just by virtue of, for instance, wanting to clean up swear words or some other moderation process. As to matters that might merit a bit of further discussion, though,
I'm sorry, I'm sorry to cut across you, but we will get into a lot of these issues in detail in the questioning, and we'll definitely come back to this issue, Mr. Scuddy, in a few moments. But before we get into the questioning, could I ask Mr. Tibbett if he wants to make any general opening remarks?
Hi. Delighted to be able to speak to the committee today, so thank you very much for the invite to speak. I thought the best thing I could do at this stage was really just to provide something of an introduction to the Ferret, because we're a relatively new insurgent organisation. We were established in 2015, and we were established to try and tackle the perceived decline in investment in public interest investigative journalism. We're a cooperative with nearly 2,000 paying members. We have places for our readers and our writers on the board, so we have quite a different business model from most media organisations. Crucially, we are the first organisation in Scotland to adopt a Leveson-compliant independent regulator, which means we're actually regulated to higher editorial standards than most of the press. And that's one of we can get into the detail of why we did that, because it's important to our evidence later on. And we also operate Scotland's only independently accredited non-partisan fact-checking project. So we're large in numbers, large in impact. We often work with the printed press. So we've worked with, our materials appeared across the political spectrum, from The Guardian, The Scotsman, Daily Record, and The National, and so on. But we're still relatively small in turnover, and I think that's what may be interesting to the committee. For example, we have had practical experience of the chilling effect, which again I know your members are interested in, where even if we won a case, and we're about public interest, a public interest story that we've been involved in, even if we won, the legal fees would have cost us about a fifth of our annual turnover. And that fundamentally is why we're very keen to see reform of defamation, and why we've supported the campaign, the civic campaign.
Excellent. Thank you very much. We're going to get straight into questions, and Liam MacArthur will lead off. Liam, please.
Thanks very much, Convener. Mr. Tibbets, I think perhaps provided much of the response I was looking for in terms of the practical effect of defamation law as it currently stands on the organisations that you run. I don't know whether there's anything more you want to add, Mr. Tibbet, before I turn to Mr. Scuddy.
I think, broadly speaking, I think our interest in this process is very much about reducing the cost and reducing the time and simplifying the process of dealing with disputes. Obviously, doing what we do, it can be controversial. It can annoy, as previous people have got, it can annoy rich people with thin skins, I think is a phrase which has come up earlier this morning and in previous hearings. Sometimes, obviously we do our best to get it right. There are disputes, and one of the things which we have laid out in our evidence, our written submission, is that independently regulated publishers, particularly those which are regulated by the Press Recognition Panel, have an arbitration process which is available and independently available to potential complainants, and it's set up to deal with defamation claims. And our argument really is that we believe that the committee should consider building in some mechanism for incentivising and encouraging people to use these statutory arbitration processes which are laid out through the Press Recognition Panel and our independent regulator, as a means of cutting the cost and reducing court time for all parties involved.
Thanks very much, Mr. Tibbet. Mr. Scuddy, I think you alluded to it in terms of what you hope the defamation bill will help achieve in future, but maybe you could set out a little bit more precisely what sort of effects the current laws around defamation are having on the way in which TripAdvisor operates and interacts with customers and clients.
So, because it's a global business, and because I'm in a role whereby I help support the business with legal matters in multiple jurisdictions, I've developed a bit of a comparative sense. And I can see where this current Scottish law sits compared to some others. And for instance, the 3-year limitation rule does mean that if a given business at a moment, and this hasn't happened a great deal, I should not overstress the scale of this. Actually, Scottish businesses, from what I have seen, by and large, don't feel the need to recourse to legal threats. It has happened, but it doesn't happen at great scale. But for instance, the long limitation period means that if in a given moment they want to attempt to use legal levers to clean up negative reviews such that they are only left with positive reviews, they can go back disproportionately far into the past, which might, if it worked, result in a real kind of imbalance in the overall picture of consumer sentiment that you would see on a given review website. Equally, even more so, the lack of the single publication rule, moreover, means that you could go back even further than that. It so happens that in TripAdvisor's case, it's fortunate enough that it has the resources to be able to consider these matters at a specialist level. It can use internal counsel, external counsel. But a smaller website might be, with fewer resources or less time to devote to these matters, might be inclined just to remove the material altogether rather than, have what it might consider to be a disproportionate amount of stress and challenge over one particular piece of user-generated content.
Okay, that's very helpful. Thank you for that. Obviously, there's a balance here to be struck between freedom of expression and the protection of reputation. I think there seems to be a common view from the witnesses we've heard from to date that this bill shifts that balance more in favour of the freedom of expression. We haven't yet heard from Scottish Government, but I rather suspect that's a deliberate intent. In your view, Mr. Scody, first, do you think that balance is now better struck in the way that the draft bill is structured?
I do think so. One specific point, just to flesh out something I alluded to earlier, is the notion that one avenue of potential attack on freedom of expression has been closed down here, because for years the method of a claimant lawyer would be to identify anybody potentially liable for a given publication and equally identify the weakest chain. Because if your primary aim isn't even damages, but it's just to get some material taken down, deleted, then you find anyone in that chain or that group of people potentially liable, and you attack the one that might be the least likely to put up any kind of resistance. The fact, as I mentioned, that the legislature has very thoughtfully tried to close off the attack against websites that are perhaps moderating, just hosting, I think is an important shift in favour of freedom of speech, in favour of those who wanted to speak in the first place.
Okay. Mr. Tibbett, I rather suspect I know the answer to this, but I'll ask it anyway. This is as better striking that balance. You see it as a deliberate shift in favour of or enforcing that freedom?
Yes, I do hope it shifts the balance towards freedom of speech. But I think Mr. Scody makes an interesting point about going for the weakest link. That doesn't just apply to online civilian commentators, if you like. One of the consequences of the current situation is that in effect means that larger media operators with big pockets can afford to take risks which smaller operators cannot take. And that has implications for media diversity and in effect competition, because the current situation in a way supports the status quo, and it makes it very hard for new entrants to grow and develop without taking on proportionally more risk. So that's one of the, again, to go back to this idea of independent regulation and arbitration, that's one of the reasons we took the decision to join Impress, was because it offered an arbitration process which we felt and hoped, in the event of a legal scrape, would help to provide a mechanism to resolve things which didn't involve a large, significant legal bill, which would basically put us out of action. And so there's a temptation for people or potential temptation for people dealing with us to say, well, it's worthwhile sending them a legal letter because we know that there's a greater potential for us to be able to stop a story coming out because we can't take the risk, whereas a larger publisher could.
That's very interesting. It leads on to my final question, which is around those pre-litigation letters. I mean, we've heard them described by witnesses on one panel as kind of threats that are deliberately there to chill and incentivise. We've heard from legal stakeholders last week that this is very much a part of the normal negotiation process and can, in many respects, avoid costly legal action down the track. I wonder where you stand, whether those different perceptions can be bridged, and clearly, Mr. Tibbett, you've been in receipt of those such letters. It'd be interesting to know what response they elicited in Perth or amongst those you collaborate with.
I regret, committee, that I can't go into details about some of these things for obvious reasons. However, I think I have worked for, I previously worked for STV as a journalist there. And again, many of the other founding directors and current directors of the fair have worked for much larger media organisations. And our experience very much is that if you work for a larger organisation, you'd be much more willing to dismiss that kind of thing as possibly regard it as the normal rough and tumble of publication. The process of journalism, and alongside that, I saw, for example, in the preliminary paper from the Scottish the Law Commission, which suggested that there wasn't evidence of this kind of preemptive, these kind of preemptive letters closing down publication. Well, I would like to reassure the committee, or at least provide evidence to the committee, that when you work for a small organisation, that's potentially your livelihood on the line. When you get those kind of letters, even when you have pro bono or an element of pro bono support, you don't take the risk, because it's not just your money, it's your livelihood, and it's potentially, as a cooperative, it's potentially our members, investment that we're putting at risk from one, just for publishing one story. And it has delayed, and it has wasted our resource. It has prevented publication. And again, just to come back to this idea that this is very much why we're in favour of reform of the law, and any kind of reform which reduces the costs dealing with these things.
Would you, though, accept the argument that one would presumably want some form of pre-litigation process to exist in a way to reduce the likelihood or the need for costly court action, and therefore some of this activity, however unpleasant it might be when you're on the receiving end, is an inevitable consequence of that, is it?
No, absolutely. I mean, I think there will always be potential for disputes, but to reiterate what we've said in our evidence, that's why we have an independent regulator who can channel people into an arbitration process. And I think that's where we would be keen to see the bill steer people, or at least take account of those publishers which have those kind of processes in place, because they benefit both sides of the equation, quite frankly. It's not just for our benefit; it's also for the other affected parties.
Yeah, Mr. Scotty, briefly, are you any comments you can make in terms of your own experience of being in receipt of such letters or correspondence?
So TripAdvisor receives many such letters from jurisdictions all over the world every year, by which I mean specifically legally tinged ones with a specific legal threat, frequently referring to defamation. Scottish ones are unusual, but they do happen. I would suggest that process is really valuable, and I would add that I think it's valuable for those exchanges to have weight, such that if the defending party sets out very clearly and convincingly why the claim or the threat should end there, but the claim pursues, and that correspondence ends up in front of a judge, and the judge should be able to act on that, and it should have some ramifications. You'll be well aware. Forgive me, I'm not up on Scottish procedure, but you'll be aware that's basically the principle in England and Wales. In other European jurisdictions, you can have it out in correspondence and it won't mean anything in terms of the how the litigation plays out at court, and the claimant party can just take another shot and ignore everything you said and have a crack at it in front of the judge anyway.
That's very helpful. Thanks, Convener.
Thank you very much. Okay, I think Rona Mackay wants to ask about the serious harm test. So, Rona, over to you, please.
Yeah, thank you, Convener. Good morning, panel. Yeah, just really following on from Liam MacArthur's line of questioning, I wanted to ask you about the serious harm test, which sets a threshold before someone can raise defamation proceedings. I mean, do you think that, well, first of all, what your views are on it, and also do you think it would dampen down the number of pre-litigation letters that have almost become par for the course? Do you think that would have an effect on it? So if I could ask you, Mr. Scody, first, please.
Well, the letters may continue because you will always get people who may feel affronted by something that's been said, and they will take a shot at framing a threat and getting a reaction out of you that they want. What matters is, as the defendant, your confidence and your understanding in the available defences and the available, how the available law is built. My sense of the change in England and Wales, that it certainly was positive and certainly did redouble the confidence of a host of third-party material, that just because something is negative doesn't necessarily mean it's anywhere near actionable.
Yeah. Mm-hmm. Because, I mean, as a user of TripAdvisor, I'm astonished at some of the comments that are on there. And, can you give us an idea of, you talk about the number of defamation actions that come from England and that there are less in Scotland. What sort of percentage-wise would you say that breakdown is?
Well, you have the letters threatening such, and you have the things that actually turn into actions.
Yeah.
Actually, in terms of things that really do become formal litigation on foot,
yes.
It's absolutely negligible. I mean, in the period I've been with the company, I've been with the UK subsidiary for 5 years, and I've experienced 2 or 3 things in England and perhaps 1 in Scotland, but that belies the number of legally tinged came in, which isn't helped by the phenomenon that everyone's heard of defamation. It's not widely understood. There's a lot of public myths that this area of law. By the way, I'm positive of this legislation because you're at least codifying things and putting many of the key lists.
Sure. So you believe the serious harm test would benefit your business? Can you also see from Ali Tibbett's point of view about why companies like yourselves with large resources can deal with threats and letters more than companies, fledgling companies who don't have those resources? Yeah,
emphatically. I'd emphatically agree with that. I came to someone with specialist knowledge of this area broadly. And everywhere I can afford to do anything like that.
Thank you. Ali Tibbett, can I ask you your views on serious harm test, please?
I think, just to reiterate what we said in the written evidence, anything which brings clarity as a non-lawyer to the kind of the thresholds which are being used is going to be helpful. It's going to help certainly journalists throughout the process of writing and researching and publishing. I think that's really the key point, isn't it? Is that it's going to codify and help. Yeah. I suppose having listened to the previous witnesses in the previous panel, obviously the concern is that it genuinely does raise the threshold rather than apparently raises the threshold and then is subsequently interpreted in a way which remains quite generous.
So how much impact do these letters have, and how much does it inhibit the work that you do? Because it's interesting to know what sort of level that's at.
I mean, to be clear, we don't get them every week. But when they do arrive, as I say, they have a disproportionate, well, certainly what feels like a very disproportionate impact on the business. We have, we don't have lawyers on tap like larger organisations. We do not. Although between us we have many decades of journalism experience, it's as much about the time and the capacity that it takes for us to deal with. And as I say, we were shocked and stunned to discover, quite frankly, that even if we were to, we're in almost all circumstances, we obviously wouldn't move to publish something which we're not confident of. But I think the key point is really that we were shocked and stunned to learn that even if we won, and even with an element of pro bono support, as I said in my opening remarks, that the costs of defending an action could easily extend to more than a fifth of our turnover, annual turnover in a year, which means it's just unsustainable. So even if we receive one letter like that a year, that essentially prohibits us from publishing a particular story, which could have a significant public interest.
Yeah. Okay. Thank you. That's really interesting. Thank you, convener.
Thank you very much, Rona. I think we're going to move now to John Finney, who wants to ask about the so-called Derbyshire Principle. John, please.
Thank you very much indeed, convener. And it's a question in the first instance to Mr. Tibbett, and good morning, panel. I hear that you were listening in the previous session. The Derbyshire Principle is one that bans public authorities from suing for defamation. Now, I'm sure, Mr. Tibbett, many of these authorities are the very people you want to get in about and inquire about, and you'll be aware that the profile of the public sector services is altered greatly over the years, with many multinational corporations delivering services. This is about freedom of expression, protection of individual reputation. The bill creates a definition, and there's an exemption for businesses and charities time to time deliver these services. I wonder, can you comment on your views of the Derbyshire Principle and how it's applied in this piece of legislation, please?
I would echo again what people have said before. In many ways, this reminds me of the debate about extending freedom of information laws. I think we would strongly support any move which would essentially follow the public pound. We have been involved, for example, in investigating things like the Scottish Futures Trust, which rapidly, which obviously hands out a great deal of public sector money, and rapidly moves into private companies and quasi-private companies, which are not, which, as I say, spend a great deal of public money, are not subject to freedom of information laws. And similarly, I think the Derbyshire Principle should follow the public pound wherever it goes as a matter of principle.
And on the issue of concerns that have been voiced by the legal profession, that is broadening the scope as previously understood, and the implications for individuals. So, for instance, doctors delivering services, other senior officials. Do you have a view on this application with regard to them, please?
I think that the principle of public money, public accountability is fairly straightforward and should be applied as broadly as possible. I don't think the committee would be surprised to hear me say that. I think that would be
indeed.
We would take.
Indeed, I'm not surprised. Thank you very much for that. I wonder, Mr. Scodie, did you have a view on the Derbyshire Principle and how it's applied in this piece of legislation, please?
There's nothing that I would add from TripAdvisor's point of view. I can't think of any particular applications, so I wouldn't add anything to what Mr. Tibbett just said.
Okay, thank you very much indeed. And you'll be predicting the next one, Mr. Tibbett, and this is about some of your media colleagues. Indeed, Penn proposed that only companies with fewer than 10 employees should be able to sue for defamation, the so-called Australia Principle. Do you have views on that at all, please?
I'm not a legal expert, and I think where the threshold is set is a difficult one for us to really rule on, in a sense, to have an opinion on. I think I would fall back on the principle, as I say, of public accountability I'm not entirely clear that it really matters the size of the organisation or the status of the organisation. I think the principle should really be, if you receive public pounds, you should be accountable, and the Derbyshire Principle should apply.
Thank you very much indeed. I take it, do you wish to say anything, Mr. Scody, on that principle at all?
Really, that I've encountered it, that the idea from Australian law that a company needs X number of people to be capable or not of saying it's always struck me as a bit arbitrary. You can be a small company with a small number of employees and still be enormous and have an enormous effect on the world and on consumers. But it's hard for me to draw that line.
Okay, thank you very much indeed. Thank you, convener.
Well, thank you very much. That's very helpful. Annabelle, I think you want to pick up on some of the comparative notes that have already been sounded.
Yes, thank you, convener. Good morning to our witnesses. If they had been able to listen into the first session we had this morning, they would have heard that I had asked a couple of procedural questions. Firstly, on the issue of a pre-action protocol, and perhaps I could go to Mr. Scody first. That is the case in England. I think it deals with other issues, media and communications claims in general, but including defamation claims. And we don't have such a thing as yet here. It wouldn't be a matter for the bill. It would be a matter for the Scottish Civil Justice Council. It has to be said. But just looking at the principle of having such a pre-action protocol, and comments about how you feel it's working in practice would be helpful. So, Mr. Scody first.
Thank you. So, as I mentioned before, and I may have a bias because I'm an English and Welsh lawyer by training, but that's what I've learned and experienced myself in other contexts, as well as defamation and media claims. And I've seen how things play out in other jurisdictions where they have no such rules, and you end up ploughing straight into litigation with sometimes no discussion and correspondence at all. In many of the cases the TripAdvisor sees, there can be a frank conversation about the rights and wrongs and the appropriate way to respond to a particular review in correspondence, and that's healthy in my submission. It benefits TripAdvisor and the businesses that challenge us, because frequently what would otherwise be meritless claims that help no one stop at the correspondence level. And the benefit of a protocol is they're so prescriptive about all of the key elements that really do need to be played out in correspondence. And like I say, above all, there can be potential ramifications in terms of costs if those rules aren't played by. So my experience and TripAdvisor's experience is that they're a good idea.
Okay, Mr. Tibbett?
I think this is one of those questions where I must confess I have no experience of it, and I'm probably not qualified to have an opinion, so I shall pass on this question.
Well, that's a very honest response. Thank you, Mr. Tibbett. Turning to another issue that has been raised, I understand, in evidence to the committee, which is that the whole process would benefit from some special hearing, if you like, on the defamatory meaning of the words at issue in contention. And we have heard this morning some information about how this plays out in England, and it seems to risk actually extending the whole process very significantly, which perhaps was not the original intention. But again, if I could go to Mr. Scody to hear his views on that. Thank you.
So I can't draw on experience that TripAdvisor's had on this niche issue. It hasn't played out in terms of the kinds of extensive court proceedings you've heard about more broadly from the academics. So I would really refer you to them. I am aware from my reading that there's been a great deal of litigation in England as the legal establishment has adapted to the 2013 law, but I would point you to others who've given more detailed evidence on that.
Thank you for that. And I, on the basis of Mr. Tibbett's very quick answer last time, unless he wants to say anything, I would imagine this may fall into the same scenario a bit too processy. I don't know, Mr. Tibbet, if you wish to make any comment.
No, I think I can confirm that I don't have much more to add on that one, and I think the academic views are probably best listened to on that one.
Okay, thank you. And one last point then, since this has been quite a brief Q&A. We heard last week concerns that, you know, some of the provisions of this legislation are a bit of a hammer to crack a nut, in that we don't have in Scotland the problem of libel tourism, and you know, more account should be taken of the reality of what is the case here on the ground in Scotland. Mr. Spoon, did you have any comment on that?
I mentioned something briefly earlier. I think there's no harm. I would respectfully suggest there's no harm in building in protections against things going wrong. If you want the rules to be built a certain way, there's no harm in them already being pointed in the right direction. And I have seen, and in my reading and trying to stay on top of the area, the centre of gravity of defamation claims that could be multi-jurisdictional have moved a bit away from London. And some claimants are looking for other places where they can bring such claims. So if Scotland wishes to insulate itself against those, I suggest that's no bad thing.
Mr. Tibbet?
I would concur with that. I suppose the one thing that we should add is, of course, that being primarily a digital publisher, we're potentially, we do write international stories, and there has, I think I have detected in the past a perception, which has always seemed somewhat bizarre to me, that media policy in Scotland isn't beset by the same issues which affect media policy in London or media policy elsewhere. And I think, which in the modern day, where, almost anything, any kind of media can be accessed from anywhere in the world, seems a bit misplaced. And I think, to reiterate what previous people have said, I think if there's an opportunity to close a potential loophole, as it were, that would allow people to sue from, or make spurious, take spurious cases in Scotland where they would otherwise be prevented in other jurisdictions, and that's, I assume the committee would agree that it's probably sensible to close those loopholes now.
Thank you for that, and thank you, convener.
Thank you very much, Annabelle. I want to turn now to secondary publishers. And as we know, the bill will exclude secondary publishers from liability in defamation. So let me ask Mark Scody first, as a secondary publisher yourself, what practically, you've already touched on this in general terms, but what practical difference will this exclusion make to your business?
Well, in terms of a practical difference, it would probably just add an extra limb. An extra element that could be called upon when facing legal challenges in Scotland. It may not necessarily change outcomes, but I say that because this defence, even if it came in, wouldn't exist in a vacuum. I know you've already taken extensive evidence on the European defence from the e-commerce directive brought in the 2002 regulations in the UK. There's a certain amount of dovetailing, there's a certain amount of overlap. So this defence would, to an extent, redouble defences rather than create brand new defences. But what it does do, I would say this is material changes, it's so explicit in spelling out a position that it's taken a while to reach under the European law. Because on a very, very strict reading of the original hosting defence that comes from Article 14 of the e-commerce directive, if you touched content at all, if you had any kind of involvement beyond being a completely blind technical operator, you risked potentially being found liable in defamation or any other wrongdoing, any other kind of tool. I think it's very healthy and practical and helpful to website operators to be so clear that not adopting the content, but hosting it and perhaps moderating it just to make it slightly more appropriate for the public in one manner or another doesn't get you on the hook. But I would add, though, there is a wider context that, of course, this world isn't of challenges to content. It's not just about defamation. There are other laws out there. There's other potential causes of action. So it's definitely helpful, definitely a positive influence, but won't be a huge magic bullet that will change the balance of online speech.
That's very helpful. Thank you. Can I ask Ali Tibbet, whether this exclusion of secondary publishers would have any impact on how the Ferret carries out its work.
I think it would, in the sense of bringing clarity about who's responsible for what, which is very important. So all media businesses of any scale, but particularly digital news businesses, often operate what you might call a distributed publishing model, where they have their website and they obviously try to get people to read content, consume content on the website, but they also make extensive use of various social media platforms and ever-changing selection of those platforms. But of the key ones, the committee will be familiar with. So, for example, anything which helps to bring clarity, for example, on the vexed question of who's responsible for moderating comments on, beneath our YouTube videos, for example, or who's responsible for comments on our Facebook, who's responsible for replies to our Twitters, our tweets, because Twitter is changing its platform all the time, and now we can choose who replies and responds to our tweets. So does that make us potentially more liable or not? I think anything in the legislation which clarifies the position with regards to defamation is going to be a huge relief. In my career, I have worked through various internal policies of different organisations. At one point, we decided that we could be held liable for everything that anybody said on any of our Facebook pages, given that they were some of the largest. This particular organisation had some of the largest Facebook pages in Scotland. That was an absolutely terrifying prospect, which would almost at one point made us reconsider whether we wanted to have Facebook pages at all. And that would actually have an economic impact on the business because of the importance of these distribution channels for our audience. So I think any legislation which can bring clarity to who's responsible for what, where, is going to be a great help.
Okay, that's very helpful. Thank you. Just building on that, we know that the bill contains a whole suite of further descriptions about what constitutes being an editor for the purposes of defamation. And I hear what's said about other causes of action being out there, but this bill is focused only on defamation, so that's why our questions are focused on defamation. So moderating posts, liking tweets or retweeting tweets does not make you liable, according to this bill, in the law of defamation. I assume from the tenor of your answers that these clarifications are welcome in your judgment, but the question is whether there are any other aspects of online behaviour that should also be captured in the bill. That question to Mr. Tibbet first, and then I'll come back to Mr. Scody in a second. Mr. Tibbet.
I suppose, speaking more broadly, there is an interesting issue to potentially address, which is that grey area between public and private, which may arise online. For example, closed WhatsApp groups, which nevertheless have a large membership, or large private Facebook groups, which have a large membership and may be influential, but are not necessarily, strictly speaking, public. There's an interesting point there to address about defamation, I think, in the sense of if, for example, the Ferret were to operate a private forum with 50,000 members and somebody said something defamatory in there, who would be responsible then? Probably not us, because it would be still fall underneath the secondary publisher rule. But nevertheless, the relationship between public, private, and direct message harassment is not as black and white as I think sometimes the people treat it. Okay,
I was going to say that's helpful, but I'm not sure it is, because it's a grey area that we might we might struggle to understand fully. But thank you for that. Can I ask the same question to Mr. Scody?
As to ground that potentially isn't covered in the definitions,
yeah.
Not that would leap out to me. They are pretty broad. They do pretty innovative and helpful things, both for users sharing content that isn't theirs, but they may perhaps redistribute, show to others using social media functions. And they're pretty wide in terms of their potential protections for website operators, so there's nothing I'd add. But in any case, you do have this sort of future-proofing at Clause 4 anyway, such that if some new behaviour arises because of a new platform that someone invents next year, there's sort of an expansion facility at Clause 4 anyway.
Yeah, that's helpful. Just one final follow-up from me, Mr. Scuddy, for you on this issue, which is to ask you this. In England, Section 5 of the 2013 Defamation Act can be used to require secondary publishers to identify authors or to remove content. Do you have any experience of dealing with this provision? And if so, what is your view of the process?
So it did one clear, helpful thing, Section 5, which was to make clear that if the pursuer, if the claimant is capable of serving process on the person who put up the content that's complained of, then they've got no action against the website operator. That's easy to understand, and TripAdvisor's been able to avail itself of that defence in specific cases where that was true. I have to say that in other respects, Section 5 has not been useful and has sowed more confusion than anything else. With the greatest of respect, if I've understood the way you put the question, you put it in a way that doesn't actually reflect what Section 5 does. Section 5 can't compel anyone to do anything, ever. Section 5 created a new defence. And if website operators don't behave in a certain specific way, that's defined both in that legislation and in the regulations promulgated underneath it, they can lose that defence. But the circumstances might well be that a whole host of other defences might be available anyway. And indeed, the English and Welsh Law Commission's guidance notes say that explicitly, saying all that will happen is that the website operator loses that one new defence. But, for example, most commonly, the European defences under the e-commerce regulations might still apply anyway. So I know from TripAdvisor's own experience and also reading academic commentary, it's largely being ignored by website operators and is substantially misunderstood by many claimants, including, unfortunately, some claimant lawyers.
Okay, that's very helpful. Thank you, and thank you for correcting that. You've mentioned defences, and that's the area that James Kelly wants to get into, and I'm going to turn to him next. So over to you, please, James.
Thank you, convener. We'll go to Mr. Tibbett first. Just in terms of the defences that are codified in the bill, truth, honest opinion and publication in the public interest. What's your views on those, and do you think there should be any additional defences outlined?
I don't have I'm aware that in a way the debate about particular definitions is kind of almost quite technical and legalistic in a sense. I think from my understanding, we're broadly in favour of what's in the bill. I'm sorry, I can't provide you with a more detailed sort of response, but that's broadly where we're at with it.
Okay, thank you. Mr. Scobie, have you got any views, particularly bearing in mind your answer to the previous question from Mr. Tompkins? Do you think the defences that are laid out are adequate? Are there any additional defences that are needed?
So, insofar as the bill sets out defences, I think arguably the best thing about it is that it codifies them and puts them all in one. In order for somebody from scratch to understand some of the key defences available, they don't have to go off reading case law and buy textbooks. It does now sit codified. That's similar to the English approach. I think it's a positive thing. Substantively, should anything be added, I wouldn't add anything here. I wouldn't add anything to the commentary from the academic colleagues who helped this morning. I noted what they said about the honest opinion defence being somewhat expanded in a helpful way, and I would echo that. I would note for this conversation that this isn't an exhaustive list of all of the possible ways you would defend a liable action, but some of those things just necessarily exist in other legislation, like, for example, the European ones I've been referring to.
Okay, thanks for that. Thank you.
Mr. Tibbett, do you have anything you want to add to that? No. Okay, all right, thank you. Sorry, my connection's all of a sudden frozen and gone very slow, so I'm struggling a bit here, but I think we'll move on to Liam Kerr now. Thank you, Liam.
Convener, I shall be brief as always. I'd like to take you, gentlemen, to the part 2, the malicious publication sections from section 21 onwards. And specifically, I'll direct a question to Mr. Scody. You were asked earlier about secondary publishers. Now, the bill would exclude secondary publishers from liability for defamatory material. However, it appears that that may not be the case for malicious publication. Is that correct? Is my reading of it correct? And if so, do you consider that to be a lacuna that requires to be filled?
I would agree, and I do think it's a hole in, potential loophole, and it echoes the other potential lacuna you referred to in a prior discussion, which is the mismatch in thresholds of harm that you need to pass. I mean, lawyers that know about defamation, claimant lawyers who know about defamation and have that in their toolkit, will equally know about malicious publication, or in the English context, malicious falsehood equivalent. You learn them together at law school, they sit together in your toolkit, and if your client has a problem, you're liable to try and reach for both. And TripAdvisor's experience, sometimes in the UK context in one jurisdiction or other, that claimant solicitors will try and throw both of those things at you. So if there are kinks and inconsistencies, they will play out. So I agree that if there are going to be improvements, if there are going to be freedom of speech promoting reforms on the defamation side, you need to echo them in the way you've been exploring on the malicious publication side.
That's very helpful. I'll direct this question to both of you, but Mr. Scody again first, just given what you've just said. So I had suggested, I don't know if you saw the session last week, but I suggested that the definition of malice might have a reasonably low threshold. And as you've just pointed out there, Mr. Scody, there's no serious harm within the malicious publication section. Now, taken in the round then, is it your view, both of you, but Mr. Scobie first, that there's a danger that business could almost use this part to bypass the freedom of expression protections in the defamation section? Mr. Scobie.
Forgive me. So I think there's a real risk, and I think the parallels are from other instances in which, so the English experience was that defamation claims became, at least to begin with, harder to bring. I mean, there's been a great deal of case law playing this out. But one of the first things that happened was the data protection claims rose because claimant solicitors looked in the palette of available legal weapons on behalf to help their clients get what they wanted. And they started reaching for alternative causes of action. So I agree that for corporates who wish to make legal threats, even if they're just threats, to employ the chilling effect you've been hearing about in other sessions, you don't want malicious publication to suddenly become more attractive and feature less hurdles.
That's very helpful. Mr. Tibbett, do you have any comment on either what you've just heard or my question?
I think I would only echo what Mr. Scody said, in the sense that I think we said in our written evidence as well that we support equivalent provisions across the two, simply for simplicity's sake, but also to prevent exactly what we've just been talking about now, which is this: people will go for the approach of least resistance, especially when they're looking to fire a legal warning shot across the bows of a journalist. For example, they're going to use whichever tools are easiest and most and appear to be most applicable with the lowest threshold that they can find.
That's very helpful. One further question then, just exactly the same as I posed earlier on. There have been differing views taken on limitation on the reduction to 1 year. Mr. Scody, in particular, in your opening statement, you supported the reduction. I'm not off the top of my head sure of your view, Mr. Tibbett, but if you accept that reduction to 1 year is the right thing, would either of you care to persuade me that 1 year is the appropriate limitation period, please?
Who would you like to speak first?
Mr. Scody.
So in the TripAdvisor experience, there's a constant influx of new reviews. You've heard some of the statistics at the beginning as to the hundreds of millions of pieces of content that exist on the site that have been accrued over the years. So if a review has impact, if an isolated review on its own, when read in its proper context of dozens or hundreds of other reviews of it, if it's going to be said to have any material impact individually, it will only be in a short period of time because it will eventually age. Consumers are smart enough to know. They're smart enough to be able to read the fact that a piece of content has got old. It may get stale with more time. in particular if it's replaced with fresher content, as more and more people contribute to the conversation and may have other points of view. In that light, I would wholly support moving from 3 years to 1 year, because claiming that one review from 3 years ago that's been subsumed by dozens of hundreds of other reviews seems like an untenable position. I can echo something you heard in a prior session. I understand France's limitation is 3 months. That is the shortest limitation period of which I'm aware. In other countries, they still effectively have an infinite publication rule, so long as something's online. I would suggest 1 year is a realistic and sensible midpoint.
That's very clear. Mr. Tibbett, any comment on that?
I think in the broad principle, I think if we're going for a serious harm test, the principle should surely be that the defendant, well, the person affected by that serious harm would surely know about it within 12 months. In our evidence, again, we reiterated this point that you may wish to provide sufficient time for an arbitration process to take its turn, as it were, to go through the process. So there may be cases where you may wish to extend that, in the sense of, if somebody was not happy with the outcome of an arbitration process that they initiated within the 12 months, would they then be able to go and take it to court? That was one thing that's worth considering. And I suppose another thing that's worth considering about digital publishing in the round is that not all publishers are scrupulous like the Ferret and have a clarifications policy which requires us to add a note to the foot of digital publications. And digital publications are not like printed publications in the sense of very easy for publishers to amend something from the date of first publication. So there may be a clause worth considering there on independent regulation, which requires a procedure which publicly notes when stories are updated, and the 1 year should possibly apply to the last time a digital story was updated, as opposed to the date of publication on the top of the story. And that may be something which MSPs wish to consider.
Very grateful to you both. Thank you, Convener.
Thank you very much, Liam. And our last two questions will come from Fulton McGregor and then Shona Robertson. But Fulton first, please.
Thank you, Convener, and good afternoon to the panel. Similar to the last panel, I want to ask about the court orders to the movement and some of the conflicting evidence that we've heard on this. Conflicting opinions, probably a better word, about Section 30 of the bill that would enable a court to order a third party to remove contentious material as an interim measure. Could I come to Mr. Tibbett first? Do you have any views on this?
I don't think we would support any measure which would be essentially a sort of preemptive takedown rule. I think we would want to be clear that a serious harm had occurred before anything like that could happen.
Okay, thanks very much for that. I suspected that that would be your view, Mr. Tibbett. Mr. Scobie, have TripAdvisor had any experience dealing with this sort of issue, and what's your thoughts on the Section 30?
It's never happened in Scotland. We've seen attempts to do this kind of thing in other jurisdictions. I think you need to be... So I would start off by having in mind that individual writers of content, even though they may, if they happen to have written a negative review, even though they may fervently, absolutely believe that what they wrote was fair and based on facts, in the face of any kind of really aggressive legal challenge whereby lawyers really get involved and the court process kicks off, in most cases, users are going to say, I don't want any part of this. I stand by what I said, but I don't want to get dragged into a court process. I'm backing away. I don't want to touch this. I don't want to have anything to do with it. There was one case, I won't get into specifics, but it ended up being in the national media a couple of years ago. Okay, of a very aggressive lawyer's approach against the lady who wrote a review. What she wrote was perfectly defensible, but in the face of the threat of a court order, she not only took the review down, but she killed her TripAdvisor account, and multiple perfectly valid reviews for other consumers' benefit were lost. In the example we're talking about, the potential to go and get interim orders perhaps even orders where the other parties involved aren't represented. I think that is dangerous. If it's going to be, I mean, were it to be done at all, I think it's asking for trouble, frankly. I think it's laden with problems, but were it to be done, I think you'd want real clarity about the thresholds you need to pass. There's been discussion of the Bonnard and Perryman rule, the ancient rule from the English defamation law, about the rule against prior restraint, but equally, I assume, forgive me, I've not read everything, but I assume you must have received evidence on the effect of Section 12 of the Human Rights Act, which specifically touches on the thresholds that need to be passed if you're going to get an interim court order to restrain publication. It essentially says, forgive me if you know all this backwards, I just have it here, interim relief isn't to be granted so as to restrain publication before trial unless the court is satisfied that the applicant's likely to establish that the publication shouldn't be allowed. So that's different to the other kinds of tests that are applied in other kinds of legal dispute. It's higher. The likelihood that needs to be established is higher than not. And this bit of the Human Rights Act, there's further subsections that talk about the special care, special attention that needs to be paid to the importance of the Convention, European Human Rights Convention's protection of freedom of speech and protection of public interest publications. So, I mean, that law is there, but at the very least, you might want some sort of explicit cross-reference to the high bar that ought to be passed before this sort of thing ought to be possible, becomes possible, because otherwise, we've already had a conversation about creative claim lawyers using all the tools at their disposal. If this becomes a relatively easy, relatively run-of-the-mill avenue, then it will be employed by those who want to close down on negative consumer speech.
Thank you, Mr. Scotty. I think that there's certainly some good food for thought there in that response. And let me also apologise. I think I initially referred to you as Mr. Scobie, so accept my apologies for that. Thanks, Convener. That's me.
Thank you very much, Fulton. Can I just ask Mr. Scobie a follow-up about Section 12 of the Human Rights Act? Because it's been in my mind throughout this inquiry, and I think I've asked a previous panel this question, but I know about Section 12 of the HRA in theory. Has it made any difference in practice? Is it that raised threshold that you just read out? Is that something that has made a material difference to the way in which litigation has been fought and won and lost?
So, not to TripAdvisor. Speaking as someone who's here to talk about the TripAdvisor business, I haven't seen it employed, but it definitely has. I know from wider background in my prior working life, it's been very important in some of the debates, some of the case law around privacy injunctions. That's a different topic, but that's a different species of publication, litigation, and court orders and such.
Okay, thanks. Sorry, Shona Robertson, I got in the way of you. So your turn now.
Thank you, Convener. Just finally to ask about the Scottish Pen proposals, which I'm sure you are aware of, which are for a new court action to provide protection from justified threats of defamation action. Just really whether you have any views on this, particularly whether in terms of how workable they may or may not be in practice. If I could start with Mr. Tibbett first, please.
I think we would broadly support measures to prevent that kind of litigation. However, as with all formal court action, we would have concerns about the costs of accessing that kind of a remedy. So whilst it might work as a potential deterrent to people using the legislation just to deter publication, I think we would have questions about how accessible it would be for small publishers.
Okay, thank you. And Mr. Scotty, same question to you.
I confess I haven't read their proposal in detail. I apologise. Two very superficial thoughts. Firstly, it may not be the only means of tackling the problem that seeks to tackle. You may also, there may also be an answer just in how costs law works and what the costs ramifications of bringing a case that has no merit and what ultimately happens to a pursuer that should never have really started. The only other thing I'd mention is that I can't offer detailed insight, but I know there's a rough equivalent in trademark law. There's a counteraction that can be brought for unjustified threats of registered trademark infringement. So there may be some useful parallels there.
Okay, thank you for that. That's helpful.
Yeah, thank you very much. That is helpful. I mean, I think the idea comes from copyright law, and I think the question that Penn are putting to us is whether that parallel should be drawn, whether you lift from the experience of copyright and intellectual property law into defamation. So I think that's entirely right. Thank you very much to Mark Stody and Ali Tibbett for their very helpful and very full evidence this morning. It's been a very useful session for the committee. That brings the public part of our meeting today to a close, and our next meeting will be a week today on Tuesday, the 15th of September, when we will continue to take evidence on the Defamation and Malicious Publication Bill. I now close the public part of the meeting and we'll move into private. Thank you very much.